Well, hello, and everybody. Welcome to our monthly webinar. My name is Alex Solo. I'm the co-founder of Sprintlaw, and today we'll be talking about IP and trademarks, covering all of the key things you need to know if you're running a small business in the UK in relation to intellectual property. Before we get into the legal content for today, a quick introduction to who we are for those who are not already clients. Sprintlaw is an online legal provider really designed to make legal simple, affordable, accessible for small businesses. Unlike traditional law firms, we don't charge by the hour. Everything we do is fixed fee. So we'll always provide a quote before we are going to start work on legal services. We cover most of the areas of business law, from helping you get your business set up, contracts that you might need with your clients or business partners, e-commerce law, whether that's privacy policies, terms and conditions for your website, data and privacy law in general, including GDPR compliance, intellectual property, which we'll be talking about today, fundraising for startups, and employment law as well. Yeah, we cover really most of the areas that businesses may need help with. We have an optional membership, but most of our clients sign up to it. It includes a platform with access to free documents you can make yourselves. If you're on our paid membership, you get unlimited quick consultations with our lawyers for legal questions as an e-signatures tool, sort of like DocuSign, credits to spend on legal services, and an increasing number of AI features that you can use to get answers to simple, quick questions of law. And there's a free tier for anyone that wants to just go onto our website and check it out. We've been around since 2017. We launched in the UK in 2020, and we've been growing very quickly. We're one of the fastest growing legal businesses globally, a bit over 9,000 clients, a growing team of 50 staff, and we are launched in 3 different countries. If you are in need of any help with intellectual property law questions off the back of this webinar or otherwise, do feel free to reach out to our team. And we offer free initial consults just to have a chat about what you might need. So do feel free to take that offer up, and I think we'll drop a link to this as well in the chat. So let's get into the content for today. We're going to be covering, as I said before, intellectual property and trademark essentials. We'll start by talking about what are the different types of intellectual property that are relevant for you if you're running a business. How can you protect your brand? How can you protect creative ideas that you've come up with? We'll be talking about trademarks. What are trademarks? Why would you register one? What's the process of getting a trademark? What happens if someone else uses your trademark? We'll be talking about copyright. What is copyright? What is the relevance of copyright to your business, and what protections does it offer? And then finally, we'll talk a little bit about confidential information, which is not technically a form of property, but often comes up in the same conversation in terms of protecting sensitive business information. So we'll run through the presentation. As I'm going through, do feel free to use the Q&A feature in Zoom to ask questions. We may have some time at the end for questions, but I also really don't mind answering as we go because it helps add color often to what I'm talking about. So I'll keep an eye on that as we go through. So let's kick off. So what are the main types of intellectual property that are relevant to businesses, and what indeed is intellectual property? Well, intellectual property refers to the intangible or non-physical assets that individuals or businesses may come to own, which the law recognizes for various purposes. And in relation to businesses, the main types of intellectual property that you'll often be dealing with are the following. You have trademarks designed to protect your brand, your logo, your name, your product names. Copyright, which protects original ideas recorded in material form. This might be things like written content, blog posts, graphic designs, images, music, books, novels, other sorts of things. Confidential information. This may be things that are not quite trademarks, copyright. It's not your brand. It's not some sort of creative invention, but it's sensitive information about your business. Maybe it's your pricing. Maybe it's the recipe for certain foods, if it's a food business. Information that's sensitive that you wouldn't want others to know about your business. We have designs. You can register the designs of physical products, for example, a furniture design or a table design. And then we have patents, which are for inventions, scientific discoveries, things like vaccines, pharmaceutical products, as well as robotics, or really anything that is a new discovery in science that's never been discovered before, can potentially be patented and gives the owner the exclusive right to that. So that's the universe of types of intellectual property, and we'll go through each of them in a bit more detail, starting just with trademarks. Trademarks are, as I mentioned, a form of intellectual property that helps you protect your brand name. And Most businesses who are trading and taking on clients will have a brand name that may be distinct from their personal name. And if you do have that name, you are able to register a right to own it and use it exclusively. Not just the name, also you can register a logo, a key phrase. It may be a name of a business, it may be a name of a product. For example, you know, the Coca-Cola company would have a trademark for Coca-Cola, for other brands it might own, like Sprite and so on. So you could have multiple trademarks for your business. It's not just necessarily for the name. And we have on the right a whole bunch of different types of trademarks: letters, numbers, words, phrase, sounds, smells, shapes, logos, pictures, movements, which is a bit more of a niche type of trademark, and combinations of things, and many different examples of those things. For most businesses, for small businesses, the main trademarks that you would be looking at getting are for your business name, your brand name, your logo, if it looks different to your brand name, if it has some sort of mark, perhaps a key phrase, and perhaps some key product names if your business is in the business of producing products. So those are the types of trademarks that you register. For example, in the case of Sprintlaw, we have a trademark for the name Sprintlaw and for this little S shape as well, our logo, and one of our key phrases, business legals made simple. Those are all trademarked by Sprintlaw. So what that means is nobody else in the legal industry, in the markets in which we are registered, can use the word Sprintlaw to promote their business, nor can they use anything similar to it. Sprint Lawyer, Sprint Legal are likely to infringe our trademark. They can't use, if they're in legal, a shape similar to this, and as well as that key phrase. So we have the exclusive rights to use that. And if somebody tries to use it, as we'll talk about in a bit more detail, we can send them a cease and desist. So we have the rights over that name, and you can maybe already see why that might be important for your business to secure a trademark if you can. Now, I mentioned there are many different types of trademarks, and here are some that you may recognize. Cadbury has its C. Eclipse Gum has a trademark for the 5, the Shell logo, and so on and so forth. The Kinder Egg. These are the kinds of things that you could potentially trademark. Now, a common misconception, people think that their trading name or their company name or their domain name somehow gives them the rights to their name without registering a trademark. These are all different concepts, and you really need to make sure that you are thinking about them separately. We have on the right the example of Nestle. So Nestle's company name is Nestle UK Limited in the UK. Their trading name is Nestle UK. That's how they refer to themselves when they're conducting business. Their domain is, of course, nestle.co.uk. And in the bottom right corner, we have their trademark, which is the Nestle name, and in this case, key brand design, if that makes sense. So similarly for your business, you want to be making sure you're understanding these different concepts. Many businesses have selected a company name and they think that they own their name. The act of registering a company name does not give you any exclusive rights to that name. There was a case, for example, of a business that tried to register Apple Limited not Apple Limited, MacBook Limited as a company. And there was no one else called MacBook Limited, so they may have been able to register that name. But of course, the MacBook trademark is a product owned by Apple, and Apple were able to sort of sue them and ask them to cease and desist. So, examples like that show that difference between a company name and a trademark. yeah, we've sort of already spoken about this. Important to recognize that that trading name is the name you use to refer to your business, but it's not a formal registered right, versus the trademark is a formally registered IP right, which gives you that exclusive right to use that name or logo for your goods and services. And you can actually stop others using it. You have a legal right to say, I am the owner of this trademark, and you may be infringing it once you get that registration. Why bother to get one? It's not compulsory to get a trademark for your business name or your brand, but it is something we recommend nearly all businesses try to do if they can get one. Um, if you don't get one, someone else could register the trademark first, and you might be forced to rebrand. This happens to a surprisingly large number of our clients. They begin as a small business, they pick a name they like, they get the company set up, they're operating for 1, 2, 3, sometimes 5, 7 years. And as the business starts to do well, one day they receive a cease and desist letter from a brand that owns the trademark, which they weren't aware of, saying, we own this trademark and you're infringing our trademark. Please rebrand. Now, they may be able to fight it, but in most cases, they might lose or they may not have the funds to challenge it. And then they're forced to rebrand, lose all of the goodwill in their name. And for some cases, it can be business ending. So it really is a risk management tool to make sure you get it and no one else gets it. Um, and Similarly, if people start copying your brand, copying your name, um, you and trading off your goodwill, you don't actually have strong legal claims to stop them doing that unless you have a trademark. You can rely on misleading conduct or misrepresentation or some other legal bases for stopping people copying you, but it's a lot harder than if you have a trademark and you're just able to say, I own this property called a trademark and you are infringing it. It's a very strong deterrent for people who are potentially using your name. You might also unknowingly be infringing someone else's trademark. As I mentioned before, um, might someone might already have a trademark or might register after you and send you those legal threats. And particularly if you're a business that hopes to sell one day or raise funding or really grow, a trademark is a valuable asset to show that you own your key IP rights. And if you don't actually own the trademark, then the value of your business may go down over time because, again, there's this risk that someone else could take it or also use it, and you wouldn't be able to easily deter them from doing so. So it's a very good idea commercially to get a trademark and secure that right. So when you're registering a trademark, there's a few things you need to choose. Of course, you need to choose what it is that you're trademarking. You also need to choose what goods and services you are trademarking it for. So, you cannot trademark for your brand for everything across all industries. The law does not allow you to do that. Sprintlaw was not able to secure a trademark for the word Sprintlaw across all industries, across food, across clothing, and across legal. When we registered, we had to select specific industries in which we operate and select particular goods and services within that industry. And that's what our registration's for. So we are registered in the legal industry, and the goods and services that are covered are things like, online legal services, legal software, commercial legal advice, et cetera, et cetera. So these are the sorts of things for your business you want to be understanding. What is it that I do? Now, some businesses trade across multiple industries. They're both software businesses and they may be part of another industry, or maybe they do food and clothing. So in many cases, you might have trademarks in multiple um, uh, uh, classes, they're called, covering multiple goods and services, and that's fine. But you have to specify what they are, and that's part of what trademark lawyers help you do when you're registering your trademark. You can see here, for example, that we have some well-known chocolate brands who are in the same class, the same goods and services, operating separate from each other. So Lindt has a trademark over Lindt chocolates. Snickers has a trademark over Snickers chocolate bars. Cadbury has a trademark over Cadbury chocolate. And each of these three are distinct from each other and unlikely to be infringing each other's trademarks. If I wanted to start doing making chocolate and I came with a brand called Linter, for example, Lint would be able to send a cease and desist because it would be too similar to the goods and services with which they're registered. However, if you're operating in a different industry, a different area, you can still get a trademark even if someone else already has a trademark. So again, you can see the example of Antler. There are at least 3 different Antlers that have registered trademarks. We have the venture capital firm Antler, we have the safety helmets Antler, and we have the luggage Antler. Now they're in 3 different industries and 3 different trademark classes, and therefore they were all permitted in their own areas to own their trademarks. So that gives you a little sense of how these classes work. Again, I couldn't start a chocolate business called Linter, but I might be able to start a luggage business called Linter because it's quite distinct from chocolate. So those are one of the requirements when you're trying to get your trademark is being specific about your goods and services and distinct enough from others who already have a trademark. In addition, you also need to have words or a name that is in and of itself distinct in nature. If you are trying to register in the computing industry, the word computer, well, that's a generic term, and you can't be the person that owns a generic term. So there are laws about what are called generic or descriptive phrases that the trademark office, when you apply for a trademark, will reject your trademark on the basis of them being too generic. Now, whether something's generic or descriptive, of course, depends on what industry you're registering in. Apple, the example I used earlier, if you were intending to sell fresh fruits, there's no way you're going to be able to get a trademark for Apple in fruits. But Apple were able to get a trademark for Apple in relation to computer equipment because computer equipment is not typically called apples or oranges, if that makes sense. So that's sort of how the generic works. And even if you have a generic name or descriptive name for your business, depending on what industry you're in, it may be considered distinct. So that sort of explains how that aspect works. For those of you who have not yet registered a trademark, a question we often get is, okay, I understand that this is important. I understand that I need to protect the brand for my business. I understand that I need to make sure that I own it and be secure from potential future action, but it costs money and can I wait till later? I'm not sure of my name even for some new businesses. Maybe I want to change it. It's a valid question, and there are different ways of thinking about the right time for registering your trademark. For many businesses, before they go to market, before they launch, or very early, when the business is just starting, that can be the right time and the most secure and risk-averse time to register your trademark. As soon as you launch, you register the brand name, you make sure that it's yours, and then you can sort of go launch with peace of mind, knowing that you're not going to be infringing anyone's trademark. The alternative is to wait to see if the brand sticks, if you still like it after 6 months or a year. But there's always the risk that someone else might register it in the meantime. And so it can be a little risky to do it that way. So, as lawyers who are in the business of risk management, we generally prefer people to register them sooner rather than later. And in the case of Sprintlaw, we registered our trademark. I mean, the first few things we did when we set up our business was we incorporated our company, we did our shareholding agreement, and then we registered our trademark because we wanted to be sure from the beginning that if we were going to spend time, money, effort, and energy in building this brand, Sprintlaw, that indeed it was going to stick. So different ways of thinking about it, but in general, the sooner that you can do it, often the better. It also takes some time, as we'll talk about in a moment, and which is why you want to get started early. Now, if you're wondering right now, am I going to be able to get a trademark? The UK IPO has a tool where you can search for a trademark. And you can see here some screenshots from the page. If you just sort of Google IPO, search for a trademark, you'll be able to find these pages. But this is the URL here. So you can search by a keyword and find out if someone else has a trademark. Now, it's not as simple as you might hope in terms of figuring out if your brand name or the brand name you might want to protect is going to be available. for a few reasons. You might conduct the search, you might find 15 matches, but again, that doesn't necessarily mean it's dead in the water because in the case of Antler, because they were in different classes, it was actually okay. So it not only matters whether there is an existing trademark, it matters whether there is an existing one in relation to the goods and services you might register for. So you can also look at what class or industry they're registered in and see if anyone has a brand that matches yours in your industry. On the other hand, even if you don't find an exact match, trademark registrations can still be infringing even if they don't exactly match, particularly for words, the word that they are that is registered. As I mentioned before, we have a trademark for Sprintlaw, but if someone started a business called Sprint Lawyers or Sprint Legal, we'd likely still win a trademark case against them because the test for infringement is there a reasonable chance that a consumer would be confused, i.e., is this business Sprint legal trading off Sprintlaw's goodwill? And the answer in that case would be likely yes because they're so similar, and so we may win that case. So you might think that you're okay after you conduct the search, but unless you're a trademark lawyer, use it as an initial guide, but don't take it as gospel as to whether indeed you are able to register the trademark. To actually find out if you can get a trademark, there is a process that can take at least 4 months, and it can take longer if there's an issue. This is why, again, it's nice to do it early on because you have to wait 4 months till you know if you've actually got the trademark. You will apply. You will get the application received by the UK IPO. They'll then publish it online. And once it's published online, two things happen next. The top row is the IP office is going to review the application and make their own determination as to whether they think that your trademark's okay. They're going to decide, okay, is this trademark distinctive enough? Are there any other trademarks we can see that are too similar to it? Does it have all the details required to be a correct application? And if they think it's okay, they can then approve it to go through. In addition, when your application for a trademark is lodged, it also goes on a public register, and any other trademark holder who's not happy about your trademark, who thinks that it might be a little too close to theirs, can independently file an objection. So it's not just that the IP examiner has to say, I think this is okay and unique enough. It's also the case that you've got to receive no oppositions from anyone else with a trademark. Now, oppositions are not exceptionally common, but they're not uncommon either. And we are all the time dealing with clients who've gone for a trademark and received an opposition from an existing trademark holder. So, and when that happens, an argument can ensue. You can either change your application or fight the opposition, and then a determination can be made, and it can drag on for sort of months and months and months. So it can become a bit of a process. In the best case scenario, the whole thing's done in 4 months. Now, in this normal flow, you don't really find out from the UK IP office if your application is even likely to succeed from their perspective. But the UK IPO also offers a service called the Right Start service, where you can pay a half of the cost of an application upfront and get an earlier initial review within 2 weeks, and then decide if you want to continue. So we often recommend that for clients, so they find out within a couple of weeks if they're likely to succeed or if they're likely to have problems. And that way you're not biting your fingernails for 4 months. It doesn't mean that no issues will occur, but the chances of an issue occurring if you make it through Right Start is much lower than if you if not. Hopefully that makes some sense in terms of how the process works. Now, we've had a good question come through. I have 2 trademarks registered in the UK. What happens if someone tries to register these in the EU or the US? Do I get a notice? Well, in the case of the US, the answer is no, you won't get a notice. The trademark registration that you get in a particular country is only valid in that country. So, for most brands, who want to register in multiple markets, you need to actually go and register a trademark um, in many markets. And in the case of Sprintlaw, we registered a trademark in Australia, in the UK separately, in the US separately, in Canada separately, in Japan, and many other countries in New Zealand as well. In many markets, we had no issues. In a couple of markets, we had issues because there were different people with trademarks there. So you don't get notified unless you are registered in that market. Now, the EU is indeed the same as the US. There used to be a more streamlined process between the UK and the EU trademarks prior to Brexit, but it's essentially it's very similar now in terms of you need to get a separate mark. So yes, these registrations are country specific. Now, there is a protocol called a treaty called the Madrid Protocol, where you can register your trademark in the UK and sort of upgrade it to an application in many other international markets, as long as you do so within, I think it's 5 months of filing your UK trademark. So many UK businesses will do so. They will, from the UK, lodge their UK trademark. Once they're reasonably sure it's going to go through, will then pick their main markets and upgrade the registration to other markets. And that's a cost-effective way without having to find lawyers or navigate the websites of many different markets. Again, you may not upgrade your registration via Madrid on day one. You might not have the budget to do so. But it's the same risk I mentioned earlier. The longer that you leave it, the bigger chance there is that someone will take your trademark in the EU or the US or another market. So it is best, if you can afford it, to get them as quickly as possible. And again, to use Sprintlaw as an example, because it's a helpful case study, what we sort of did, we registered in Australia and the UK and New Zealand from the very beginning, because those were the key markets that we wanted to go to. And then after about 3 or 4 years of operation, we decided we might expand to other markets. And then we did a second round of applications to several other international markets. And in fact, had a couple of issues where there are people with similar brand names in some of the markets we tried to enter, and they may not have had we may not have had those issues had we done so from day one. So that gives you a bit of a sense of how it works in practice. So think carefully if you are planning to expand internationally about the timing of when you get those trademarks. And again, if you can afford it, it can be really great to just grab them all from the beginning. Deborah's asked, my brand's made of 2 words. When checking the register, should I only check 2 words together or also single words? Does that make it more difficult to register the trademark? Look, I think lawyers specialize in conducting these searches. So I think there's many different ways a lawyer would actually search if you were given if they were given your brand name. It would depend on what the words are, but they might search for more than just the 2 words and each word separately. They might search for variations of each of the 2 words as well. But certainly, if you want to get a sense yourself, again, you may not be able to determine either way without the professional experience. But yes, what you said is definitely prudent to do. You can search for the 2 words and then each word individually and see if there are people with phrases that look similar. Having a 2-word brand doesn't automatically mean that it's harder to register. It's more about whether what's on the register and is it likely to be confused with another mark, or is it too descriptive? If the 2 words are unique and not regularly put together, or they're made up words or whatever it is, then it might have a very strong chance of being a trademark, getting a trademark. If they are generic words that are used in everyday conversation in the particular class that you're registering in, then it might be more difficult. So it's more about that than necessarily the length. Of course, yes, like longer phrases tend to be more distinct in nature. So it may be true that the longer phrases are safer, but many people have 1 or 2 word trademarks. So you certainly, based on the number of words alone, it doesn't mean that you can't get one. Okay, we have a question here about NDAs. So we'll come back to that one. I'll leave this question open for when we start talking about confidentiality. Coming back to trademarks, this is the examination process. And as I mentioned, it can take some time. So best to get started early. And once you have your trademark, what can you actually do? A very reasonable question. Well, um, if you've got a registered trademark, you have the right to send a cease and desist letter to anyone who is using your trademark or misrepresenting themselves as associated with your brand. You can ask them to cease and desist. You can ask them to compensate you for your losses, or agree to certain terms. If they've profited off your trademark, you can ask for an account of profits, i.e., you can ask them to pay you some or all of the gain from their infringement, and you can collect damages from them as well. So, it is a powerful tool, and in our experience, the cease and desist usually work quite well, and we've seen many claims for damages made. For uh, clients that of ours who had a trademark, someone else was using it and making money off it, and then compensation had to be paid as well. So it is a fairly powerful right once you secure that brand right. Notice Andrew asked a question: are the trademark classes the same in the EU and the US? They are broadly similar, yes. There's something called the NICE classification, which is sort of a global standard in terms of how trademark classes are set up. And for those that are wondering what classes are, I mentioned earlier, classes are kind of like industry. So, for example, there's a legal class, which I think is class 42. And that's the class Sprintlaw is registered in. There's one for clothing, there's one for food, there's one for agriculture, etc. So yes, the class numbers are fairly similar globally. There are small differences in the scope of the classes in between the US and the UK. But in general, it's pretty much the same classes. So for most of our clients, they end up with the same class registration across markets, with a few niche case exceptions. So that was some of the content on trademarks. Now let's talk about copyright. So copyright is a different form of intellectual property, which is designed to protect creative original works that are recorded or fixed in some form. So the key elements to copyright existing are that they're original, they have this element of originality, and also that they are recorded in material form. So it's often said by lawyers that there's no such thing as a copyright in an idea. If you have an original idea, that's not copyright protected. It has to be recorded in some form. If it's a song, the chords have to be written down, or a recording of it has to be made. It's not the idea of the song in your head that will be protected. And if you have an original idea for a business, that may not be copyright protected. Of course, if you create an original strategy document or deck, that may be copyright protected, that deck itself. So important to understand you have this originality requirement and then recorded or fixed in some form. Now, there are specified types of copyright in the Copyright Designs and Patents Act 1988, including literary works, dramatic works, artistic works, and musical works. So these are the core types of intellectual property. And within them are where all of the various things that attract copyright protection and that you might be familiar with live. So paintings are artistic works, photographies are considered artistic works, poems, literary works, songs, musical works, screenplays are dramatic works. And so for core copyright protection to apply, your creation must fall in one of these categories. Now, in relation to business, photos, computer software, technical manuals, databases, computer games, diagrams, advertising jingles. These are the kinds of things that apply in business. And of course, if you are a creative who is producing music or novels, then of course in your business, many of these other types will apply. But if you're not in one of those sort of creative industries, it still can apply to much of what you create. In addition, there are what are called related rights. So other categories of copyright, which are basically manifestations of the core works in another form, which get their own protection. So, for example, if you have a song that you've created, that song itself and the chord progression and the structure of it may have copyright protection. And if you then record that song on a CD, people don't really do that anymore, but a digital recording or otherwise, that recording itself will have a secondary copyright, if that makes sense. And it's the same with film and video recordings, and so on. Sort of mediums that capture the original copyright. So important things to understand about copyright. Copyright arises automatically. You do not have to, like you do with trademarks, go and register your copyright. In relation to trademarks, you go to the IP office and you go through this 4-month application process or longer, and you get a certificate saying you have a registered trademark. In the case of copyright, there is no such process. Copyright is automatically owned by the author of the work at the moment of creation. So the moment that you finish that song or finish that novel or finish that presentation or complete the software code that you were writing, that if it meets the test of being original enough in what you've created and in material form, you own the copyright. And that gives you the right to exclusively reproduce that work, share it with people, publish it, share it with the public, and so on. So authors own copyright, and that's really important to understand. And if in business you have important copyright for your business, maybe your business is a software business that relies on the originality of its code. Maybe you've created important presentations or ways of doing things in writing for your business that are copyright protected. Without any contracts, all of that copyright is owned by the author. Maybe it's an employee, maybe it's a contractor that worked for you. They own it by default. That's why it's critical for your business to protect its copyright that you have written agreements with anyone that works in your business or for your business producing things that may attract copyright. Now, if you have employees, this is normally handled in an employment agreement. Most people will have read an employment agreement and may have seen the section in an employment agreement called intellectual property, which says, I, the employee, hereby agree that anything I create in the course of my employment will hereby be assigned automatically upon creation, at the moment of creation, to my employer, essentially stating that anytime an employee does work for a business, while technically they own the copyright at the moment of creation, they've agreed by contract to transfer it to the business. If you have contractors that have worked for you, maybe they've done software coding or created images or written works or music or otherwise, they again are the default owners unless they've signed a document. It might be a supplier agreement, a contractor agreement, service agreement, whatever it may be called, which says, I, the contractor, hereby agree that anything I create for your business will be owned by your business. If those words are not there, then the author still owns it and you could be in trouble. So it's really important to make sure you've got proper documentation that shows that anyone that created your copyright or worked on your business, even if you're not sure if copyright exists yet, make sure that you have something to say. To the extent that you created anything original, it will be owned by the business. Now, there are these documents called IP assignment deeds, which we use a lot, particularly after presentations like these, where people say, oh no, someone did a whole bunch of stuff for me and I didn't get them to sign anything. You can sign these simple 2-page documents, which have retrospective effect. So, I, the signer of this document, hereby agree the stuff I did for you last year is yours and I transfer all copyright to you. So you can do some cleanup work if there's stuff that you've missed. And it can be useful to have one of those deeds as a template handy in your business if you ever need to just clean up some copyright ownership that wasn't properly documented. So it's not all a big issue if you haven't done it. But of course, the issue is, can you convince the person that created it to sign that deed, or might you need to make some sort of payment to them in order for them to do so? So that's more of a practical question. In addition to copyright being transferred, it can be licensed, and your business may choose to license its copyright, its original works. Maybe it's music, maybe it's a video, maybe it's written content to someone else for some use. You can do that. You can rent out the IP without transferring it to them. And typically there's a contract that says, I allow you to use my copyright for, this amount of time in this way, provided that, you pay me some amount of money for it. So that's one way to sort of monetize your copyright. I noticed Richard's asked, can you explain how computer software can be protected in a bit more detail? I think I covered that. I think in this section, but in general, if you are creating a computer software, your business is involved in development of software, then the business or those running the business should want to make sure that everyone who's worked on that software, the developers that have worked on it, have signed at minimum an IP assignment deed, and if they're employees, they've signed employment agreements. If they're contractors, they've signed contract agreements or contractor agreements, which contain the crucial words, everything I create is owned by the business. Best practice is to have a list, whether it's in GitHub or otherwise, of everyone who's worked on your software code, and then have corresponding IP agreements for all of them. So if anyone ever calls into doubt that you own your software, you can say, well, here's a list of everyone that wrote the code, and here is all of their documents confirming that they transferred the IP to us, and therefore we own the code to this software. So hopefully that kind of answers that question. Now, how long does copyright last? Well, trademarks, I mentioned earlier, last for 10 years from the date of registration and can be renewed. Copyright lasts for a lot longer. So for most types of work, they last for 70 years after the death of the author. So if an employee does some work for you, then transfers it to you, it remains exclusively yours until 70 years after that employee passes away. It seems strange, but that is how the law works. And so you have a long time period during which you have exclusive use. And there are some different dates for certain types of copyright, but in general, it's quite a long time. So I mentioned, and just to re-highlight, we talked a lot about creative works, but in business, the key assets that we're talking about when we're talking about copyright are, your software code, graphic designs, photos and videos, business templates, and collateral. If they're not purely functional, there's something original about them that you've created for your business, then that can be copyright protected. Ad copy, books, manuals, illustrations, branding, and strategy documents. These are the kinds of things that, you're going to be wanting to make sure that you own. And again, those employment contracts or contractor agreements can cover a lot of that stuff with the correct copyright clause. So key questions to ask when we are dealing with copyright. We not only want to think about protecting our business's copyright, we want to make sure that if we're using other people's stuff, we have their permission to do so. Otherwise, we might be infringing their copyright. So on the business side, you obviously want to know who owns that copyright, who created this stuff, and did they sign a contract of some description, whether it's an employment agreement or otherwise. And then if you're using third-party stuff, so on your blogs, you're embedding photos, or maybe you're recording a video and you've got voiceovers or footage in there, or maybe you're creating software and you've copied and pasted some open source components. You want to be asking the question, am I allowed to actually use this stuff? Have I got permission from the owner of the copyright to use this? Because if you don't, you could be infringing their copyright. And, there are many websites out there that offer royalty-free photos. Some of them say only for personal use. So you've got to make sure you've got the appropriate rights to use them. Same for music and so on. You might be thinking that whenever you're scrolling on Instagram or TikTok, you see people that seem to be using copyrighted materials, copyrighted songs all the time. How might they do that, given that stuff is not their copyright? Well, those platforms pay and have deals with a lot of the major record labels and smaller record labels to pay license fees whenever artists' music are used on their platform. So a fee is paid by the platform when users are using it. And often those platforms won't allow it for commercial promotions or paid ads as well. So even though the platform might block you if you try and use copyrighted content, it's not perfect. It might miss stuff. We've had many clients use copyrighted content for marketing and received cease and desist, or in some cases, bills from the copyright owners. It's not that hard these days to trace if your stuff's being used. So just be careful when you're sharing content online, if that makes sense. And uh, if you are wondering, well, how do you protect your own copyright? Um, a few key steps. One of them is make the ownership clear. If you're publishing things online, use that copyright symbol so you can put people on notice that this is yours and they can't copy it without your consent. This copyright symbol does not require registration, and it doesn't actually have any clear legal or piece of legislation or regulation behind it. It's just a conventional way globally to notify people that this is copyright protected. And so you're welcome to use it if you have work that you think is copyright protected to tell people, to deter people from copying it without your consent. Again, make sure you've got those contracts in place and if possible, keep dated records that the actual stuff was created. Because again, if anyone ever asks, do you own this? You can't produce a certificate because there's no such thing as a copyright certificate, but you can say, this work was created by these people on this date, and here's the contract, therefore it's mine. And that's how you sort of generally prove ownership of copyright. And if someone is infringing a copyright, similar to a trademark, you can send them a cease and desist letter. You can ask for payment or compensation. You've made money off my works. You must compensate me for it. You must stop using it. If you see it being used online, you can also contact, for example, social media platforms have processes where you can say someone's using my stuff without consent. And they might ask for evidence, but even without evidence, they often will just take it down and conduct an investigation. And then there are sort of further legal actions that can sometimes be taken as well. Notice we've got a few questions here about copyright. Deborah has asked if I use images or videos from my company's social media that come from free websites like Pexels, is that infringing any copyright? I'd have to look at the Pexels terms and conditions, but that, as I understand, is like a royalty-free image site. So you should look at the terms and conditions of Pexels and see whether they have any um, uh, conditions of use. But sites like that usually allow royalty-free commercial use for many of their images. So as long as they allow royalty-free commercial use of their images, then yes, you can. If they allow royalty-free personal use of their images, you might be infringing it by promoting your business. And then it might be that they have a mix of both, which some of those sites do. So just go to their website and have a little bit of a look, and you should be able to sort of figure it out. If you're a Sprintlaw member, you can book in a call with one of our lawyers as well, and they can have a bit of a chat about it with you. That's a good kind of question, but yeah, it's usually okay if it's a royalty-free website. Question here: if we created the content for a journal, but a third party designed it, should we have an IP assignment deed in place with them? Yes, ideally. Like if what they came up with in terms of like designing the content or presenting the content was original, which it often is, if it was designed specifically for your content, then that creator, the designer, would by default be the author and have some rights in it. And then if you start using it, theoretically, they can make a claim against you for infringement of their copyright and demand compensation. So best practice would be anytime someone's doing work for you, get them to sign an IP assignment deed or some other contract with that phrase in it. I, the designer, hereby assign all my IP rights to you in exchange for the payment or whatever's been undertaken. So yeah, I would suggest doing that if you can. Processes, user journeys protected by copyright? That's a good question. The user journey itself, if you've designed it in like a wireframing tool and it's an original user journey and somebody copies that and uses it, potentially, provided that user journey is original. If that user journey is not original, it's like let's say it's like a login flow that's been done a million times before, then it may not be original enough. If someone creates a software that's similar to your user journey, again, you didn't record the user journey in a software format, so the user journey might be protected, but the underlying idea that it was expressing may not be protected, if that makes sense. So, usually if you were going to see a case for a user journey infringement be successful, you can imagine standing in a courtroom with user journey number one on the left, user journey number two on the right, and you'd be saying, look how similar they are. If you can't say that and someone's just taken the concept of user journey and done something with it, potentially not. So that's sort of how it works in practice. But certainly if they're original enough, user journeys could be protected by copyright, but if they're just functional, potentially not. When you have a copyright date on the bottom of your website, should the date be updated each year or should it remain the date of creation? Should you update it if you make any changes to your pages? Yeah, look, it's not um, it's not a really big deal. The date that you put at the bottom of your website, it often um, best practice might be to show a year range, so you can show the date of creation from the beginning of your website until today's date. The date that you put there is not going to affect the enforceability of your copyright. And I would say people often use the date at the bottom to show that the website is current and is updated, which is not really about copyright. It's just helping people understand that this website is still an active business. So I'd say most common practice is to use the current year at the bottom. Um, you could use a range of years, which would technically be more right under copyright law, although to be honest, I haven't seen that done that often. But again, the copyright symbol just puts people on notice, and the year, again, probably doesn't have that much evidentiary value other than to show people that this site was recently updated. So yeah, short answer, maybe just use the current year or a year range would be the best practice. Um, okay, Emily has asked a question. How do copywriting food recipes work? Recipes are really interesting. And yeah, that the underlying recipe itself is generally not protected by copyright because again, it's as I said at the beginning, copyright doesn't protect ideas. It protects the expression of ideas. So now, if you have a website or a blog with a detailed written description of the recipe, with story around it and photos and illustrations and pictures of the food being cooked, that has a much stronger case for copyright because that's not just the recipe, that's the way the recipe was put together and recorded in that fixed form. So if you saw someone who copied parts of that and reproduced that recipe in that same way, then that expression of the recipe may be infringing the original. If someone just copies the recipe, like you've written it somewhere and someone's copying it and serving it, that wouldn't be an infringement of copyright. And famously, KFC, and we'll talk about confidential information in a moment, have their 11 secret herbs and spices. They keep them secret as what's called a trade secret because they don't actually have copyright in those 11 secret herbs and spices. If we all found out about them, I think people have now reverse engineered them. We can make KFC and KFC can't say no, that combination is owned by us. So it's more about the expression of the food recipe rather than the recipe itself. I saw this question above about two companies with NDA fit in this context. Yeah, I'll have a look at that on the very next slide around confidential information in one moment. Just one more question on copyright here. How does copyright work for software co-created with AI? That's a very interesting question, which is not fully answered. AI is developing very quickly, and there haven't been many court cases on copyright and AI, and there's some laws that have been proposed around how AI will be regulated. If the short answer to the question is if so copyright can't be owned by a machine. So if you gave AI a prompt and it like spontaneously created all the code for your software, it will be difficult to say that you wrote that code and that you own that software, although there are arguments being made that maybe you are the author through the prompt. If you're using it in collaboration, with an AI, and it's you're kind of deciding what to build, editing the code, combining modules together, design decisions and all that sort of stuff, then there may be parts of it that are created by you. And I think probably whilst a wholly created software with AI might be argued to be owned by an AI, I think most lawyers would say that if you were to create an app from end to end, an original app with its own design and software that you wrote together with AI, reprompting it, bug testing, and getting it to fix, that original work of creating that software, is probably likely to be considered to have copyright in it. But it's a little gray because a lot of the definitions and I've shared around how copyright is contemplated doesn't really think about AI software. So it's an open question. And yeah, if you are building like an AI startup or starting to write software with AI and you want some clarity over copyright issues, it may not be a bad idea to get some legal advice, particularly if it's critical software, because there are other issues as well where you could be infringing other people's copyright without knowing it through using AI. AIs often will pull in open source libraries and take software from other places and chuck it in your software code without you realizing. So there are various issues to be aware of from a legal perspective. So final slide, and noting we have a couple of minutes to go, I'll probably go a few minutes over if anyone wants to ask some questions. But just talking about confidential information. So confidential information is not really property in the sense of the legal definition of intellectual property, but we talked a lot about how copyright does not exist in ideas, but you might have some really valuable ideas for your business, really valuable information for your business. Maybe it's the suppliers you work with, maybe it's your financials, maybe it's ideas for your business, maybe it's market opportunities. You may have really original stuff that might be quite creative, but it's not protected by these other forms of IP. So people use the law of confidential information as a way of protecting that sort of stuff. And for confidential information, for information to be considered confidential, there are some general legal principles around automatically getting the legal protection of confidentiality when someone's been told that it's confidential. But the best way to make sure your information remains confidential is to have someone sign a contract or a document before you share it with this information with them, acknowledging that they won't tell anyone. And that might be what's called an NDA, or non-disclosure agreement. Or if you have employees, you can just put that as a paragraph in their employment agreement, or if it's a contractor agreement, you can put it on materials like a pitch deck. You can say this deck is to be kept confidential and not shared without our consent, and make it clear when you share the information that it's confidential. People often put confidential as a heading on emails. That helps as well. But the most common tool used by businesses is these NDAs, which most people would have encountered before. And whilst it's not a property right, it basically says if you tell anyone what I'm about to tell you, I may be able to sue you for breach of this NDA. So most companies we recommend should have an NDA template that they use whenever they're about to share confidential information. And as long as you get that signed, you have at least some protection from people disclosing that information. So now just to turn to the question that we had earlier, we say two companies are having an exploratory discussion about a collaboration. Each has called us about discussing its strategy and progress so far. They signed mutual NDAs. How specific does an idea have to be for the disclosure to be able to say it was copied as a result of the conversation? If a disclosure says they've made some progress developing a service for customer type X, does that now block the other company from building the same service or product? It's an interesting question. The answer to that question turns very heavily around the wording of the NDA. As I said earlier, NDAs are not a property right. They're basically just a contractual promise between parties to do whatever that document says. So if the NDA is very long and comprehensive and talks about scenarios like the one you've discussed, it might be the case that there's high risk for someone who's doing that, it could be argued that they relied on the information. Many or most NDAs will have exceptions to the NDA, which say, first of all, that they expire after a number of years. Second of all, that they do not apply to information that was already in the public domain at the time that it was told. They also may have an exception that says, if I was working on this service or product prior to commencing conversations with you, this NDA will not limit my ability to continue working on it. And many times lawyers will draft that in for this exact purpose. So the answer is sometimes it might matter, sometimes it might not. It really depends on the wording of the NDA. Um, and in fact, we do give advice from time to time on this very case where people have signed an NDA and they want to know whether they can continue progress on it. So it's the kind of question you may ask for a lawyer in a specific case. I would say before you sign an NDA, you don't want to be in a position where you're already working on something, then you sign an NDA and someone tells you about the same thing, and then now you can't work on the thing you were already working on. So just be careful before you sign them in these kinds of cases to give yourself the flexibility. And often when we're reviewing NDAs, we're suggesting exceptions like this so that you don't end up in this gray area where you might be copying or might not be copying. So hopefully that's helpful and answers that question. So that was pretty much all the information I wanted to cover for today's presentation. If there are any more questions, happy to stick around for another few minutes. Otherwise, I hope people have found this really useful. We do these every few months. If there's any topics you'd like to see us cover, please do shoot an email to our team. And otherwise, looks like there's no questions, so we can wrap up. But thank you all so much for attending, and I'll see you next time. Bye.